Very good evening, friends. Today we have the privilege of having with us CS and insolvency professional Manju Mundra ji from Indore. She has been with us on earlier occasions also and has guided us on various topics, including case studies on compromises, arrangements, and amalgamations. Today, she again has acceded to our request to guide us on case studies on these mergers and amalgamations. With this, it is over to Manju Mundra ji. Manju ji, please.
Thank you, sir. Thanks a lot. First of all, I must thank for invitation, and I must thank you for getting the 1000 subscription. Thanks a lot, sir, for the noble cause you are giving the time. Thanks a lot to you. Everyone is being benefited from you. Thanks a lot, sir. Now should we start our
Gupta Sahab, actually, Manju ji, 2 minutes ke liye, we are extremely sorry. Gupta Sahab, lots of congratulations.
Oh, thank you, ji. Thank you. It is all yours.
Milestone. It's a good milestone to start with.
Yes.
And it being a technical subject, naturally,
Yeah,
those
definitely.
who are interested, only they can watch the channel.
No, it's highly helpful. Highly helpful.
Thank you. Thank you all. Please, madam, start.
Now I'll sharing my screen. Is this visible to all of you?
Yeah.
Yes, madam. It is visible.
It is visible. Okay. So our today's topic is on mergers and restructuring.
Madam, we can do it in slideshow from.
No, I'll do, sir. First of all, I'm just introducing. Then I'll start the slides.
Okay. Thank you. Thank you.
Okay. So mergers and amalgamation is a very good topic and recent topic which is being used under the Companies Act as well as under the IBC. We have to follow a lot of regulations, rules and provisions for the mergers and amalgamations, like under Income Tax Act, under SEBI's Act, LODR Act, and so on. So many regulations and rules are there. Now, I'll just give you the brief of the mergers and amalgamations. What are the steps under Companies Act? Under the Companies Act, the name is compromise, arrangement, and amalgamation, while in the common parlance, we just say it M&A, merger and amalgamations, mergers and acquisitions, like that. Now, under the IBC Act, we must understand the nexus between the mergers and amalgamation under Companies Act and under IBC Act. What is the main point of this? The first point is that under the Companies Act, the mergers and amalgamations are willingly taken, that both the parties or all the parties are taking the mergers and amalgamation route by their own willingness. But under the IBC Act, this is not willingly. This is through the resolution plan only. When one party is ready to accept the distressed assets, then only mergers and amalgamations takes place under the IBC. Now, under the Companies Act, there are two stages of the mergers and amalgamation. First stage is to do an application to the NCLT for the directions for arranging or convening the meetings of the shareholders, creditors. The creditors includes unsecured creditors and secured creditors. Under the Companies Act, we have the unsecured creditors and secured creditors, while under the IBC Act, we have financial creditors and operational creditors. So this is the difference. Then first stage, the directions are required of the NCLT to convene the meeting and get the approval of the shareholders and creditors for the scheme of the merger and amalgamation. Sorry. Then once the meetings are convened and approval of the shareholders are taken, then second stage motion is started. In that stage, we take the permission of the NCLT for the scheme of merger. And after getting the approval of the NCLT for the scheme of mergers, then it becomes the final and it comes into effect. So there are two stages. I think so Gupta ji must have explained you all the nitty-gritties of these resolutions, these all the provisions under the Companies Act, because section 230 to 231, 232, and there are various sections like up to 240, which deals with the mergers and amalgamations. There are two types of mergers and amalgamations under the Companies Act. First is normal merger and amalgamation, that is through the route of NCLT, and the another one is fast track mergers and amalgamations, that is not with the NCLT but it is with the regional directors. This is available only to the small companies as per the definition of the Companies Act. So that route is available to the small companies, that is under section 233 of the Companies Act. So this is the basic thing, because after IBC came, then so many industrialists, businessmen, and another persons have started thinking of taking over the distressed assets. Previously, no one was thinking to take the distressed assets. So now, under the IBC, some of the notable distressed assets deals under IBC are like Bhushan Steel, Reliance Communication, Fortis Healthcare. So we can see the case of the Bhushan Steel first. Under the Bhushan Steel, there were default of around 57,000 crores. The company was reporting net losses, but actually the company was having operating profits. The loss was due to heavy burden of interest on the loans. That was the main reason. So Tata Steel has started bidding for this and has finally took over the Bhushan Steel. And after taking over the Bhushan Steel through its another subsidiary, Vamnipal Steel. So after taking the Bhushan Steel and managing it, Tata Steel was able to make the operating profits better in the Bhushan Steel. And the name of the company was changed from Tata Bhushan Steel Limited. So now this is the brief about the mergers and amalgamation. If we want to know anything about this procedural, then we can discuss during the course of our question answers. Now I'll start case study. Is it properly visible?
Yes, it is visible.
Just a minute. So first of all, I'll just elaborate the facts of the case. So accordingly, we'll go for the question and answers. So we have to be very particular about the points that we are discussing right now. There are two companies. One is Junior Private Limited, Mumbai, that is transfer company, proposed to be merged with Senior Limited, Delhi, transferee company, and filed a scheme of amalgamation with the respective NCLTs on 16/4/2021. The appointed date was 1st October 2019. Facts about the transferee company. Transferee company is Senior Limited. So there were 500 shareholders of Senior Limited holding share capital of 225 crores. There were 5 secured creditors having loan amount of rupees 300 crore and 70 unsecured trade creditors of having 500 crores amount. I have just briefed all these data in one slide after this, before question answer, so that will be easy for you. So there are 500 shareholders, 5 secured creditors, and 70 unsecured trade creditors. The net worth of the company is 1200 crores. No consent affidavits were enclosed for transferee company for anyone except of the 5 secured creditors. It was observed by the NCLT that the application has no annexure of auditor certificate regarding accounting standard compliances. The basic thing that I would like to elaborate is that while filing the first motion application, if we want the dispensation of the meetings of the creditors, then we must give the consent affidavits of the secured creditors or unsecured creditors. So that is relevant to this. No consent affidavits were enclosed for transferee company for anyone except 5 secured creditors. Now transferor company. There are no secured creditors in Junior Private Limited. but there were 10 unsecured creditors of rupees 3 crore and consent affidavits have been attached with the application of merger of 9 unsecured creditors having value of rupees 2 crores. Now this we should see that there were 10 unsecured creditors, but consent affidavits were attached of 9 unsecured creditors and total value of the creditors were 3 crores, while the total value of 9 unsecured creditors were of 2 crores only. So this is the position of unsecured creditors. There were no secured creditors in Junior Private Limited. Now there were 10 shareholders having 5 crores capital, out of which 9 shareholders consent affidavits been provided with the application. One shareholder was the transferee company for 25% shares. So no affidavit was provided on the ground that it is transferee company in the scheme itself. So automatic consent is there. So the clarity is that there were 10 shareholders. Out of that, one was the transferee company, that is Senior Limited, for 25% shares. So no consent affidavit of Senior Limited was provided, thinking that it is in the scheme only. Now, what is the proposal and consideration? That is, all the assets and liabilities of the Junior Private Limited will be transferred to the Senior Limited. The name of the transferee company will be changed from Senior Limited to Superior Limited. The man object clause will be altered by adding a new clause of doing business of transfer company. The authorized capital of the transfer company will be added in the authorized capital of the transferee company. So I have included all these things because there are separate provisions for all these things. So that's why we can discuss those provisions. So I have included everything. So the name is being changed, main object clause is being changed, and authorized capital is being changed in this case. The transferee company, that is the Senior Limited, will reduce its paid-up capital, paid-up share capital by rupees 25 crores as provided under section 66 of the Companies Act. The transferee company also proposed to buy back its shares up to rupees 20 crores. New redeemable preference shares are being issued by the transferee company in the ratio of 1 share for every 5 shares to the rest of the shareholders of transfer company other than the transferee company as per valuation done. What happens in the merger cases, that valuation is to be done by the valuers. According to that, swap ratio is being decided and transferee company has to issue the shares to the other shareholders, because transferee company is also a shareholder in the transfer company. So that will be the shares will not be issued to the transferee company, rather than it will issue to the other shareholders. Now, what is the another case? Transferee company wants to create a trust and transfer its shareholding in Junior Private Limited to the trust, so that new shares in swap ratio will be issued to the trust. So this is a different angle. So this is a table just I have given for the convenience of all the participants. That is a Junior Private Limited and Senior Private Limited. So whenever when we'll answer the questions, it will become easy for you. Now we'll start MCQ. If anything is to be discussed in the facts of the case, then anyone can ask or can discuss. Or should I go ahead?
Madam, I will request you to just devote 5 minutes for brief of this compromise arrangements and amalgamations. Yes. Before we start. And another request I would like to make to the participants is, although we have circulated the case study in the group, but there may be one or more participants who is not in our group and has not received the copy of this case study. So he can individually message me on my mobile number, which is 9811117243. So I'll immediately send him the case study so that he can refer it back.
Yes. So I'll just brief the facts of the case. Junior Private Limited is a transfer company and Senior Limited is a transferee company. Means Junior Private Limited will be merged into Senior Limited. Okay. So this company is Junior Limited is in Mumbai and Senior Limited is in Delhi. Share capital 225 crores Junior Limited and 5 crores Senior Limited. Number of shareholders 500 in Junior Private Limited and 10 in Senior Private Limited. Secured creditors 300 crores and nil. I think so. I've just Done. Just a minute. I think so. I've just written the name, opposite name by mistake. Yes. So just read it opposite. This is the data of Senior Limited. Should I correct it right now?
Yeah, please correct it.
Madam,
That
please
is-
share it with me also so that I can again circulate it in the group.
Yes, yes. When I'll
And the
correct it, I'll just
revised PPT, you circulate this.
Yes, yes.
This is just like that. From share capital, the data is of Senior Limited in Junior Limited's column.
Okay.
That's all. Otherwise,
ma'am.
it's okay. Huh?
Okay, okay, madam.
Only share capital.
No, from share capital. Share capital 225 crores is of Senior Limited. Number of shareholders 500 is of Senior Limited. Secured creditors 300 crores amount is of Senior Limited.
So can you
And
change
number
the
of
name on the
secured-
top?
Why don't you
Name on the
title?
top. Name on the top.
Title only. Yeah,
Title
Title
only.
only. Huh.
And
So first
then
two
Change the
lines.
title.
Yes,
two lines,
yes.
only 2 lines. Top
First
2
two
lines.
lines are interchanged.
Yeah. Can you change it?
I'll just try to write it.
हो जाएगा मैडम, हो जाएगा इसमें.
हाँ, हो जाएगा सर.
Junior Limited.
Junior Private Limited, anything we can write like that. This is Mumbai and this is Delhi. Okay, now it's all right. So Senior Limited is having 500 shareholders, 5 secured creditors and 70 unsecured creditors. While Junior Limited is having 10 number of shareholders, no secured creditors and 10 unsecured creditors. Now consent affidavit, that is another point. In Senior Limited, not of any shareholders, not of any unsecured creditors, only of 5 secured creditors, consent affidavit has been taken. What is consent affidavit? That is for the dispensation of the meetings of the creditors or shareholders, they have to give the consent affidavits. And in Junior Limited, they have received 9 shareholders consent affidavit and 9 unsecured creditors consent affidavit. And there were no secured creditors in Junior Limited. So this is the brief.
One more factor, the 2 crore. No, 9 shareholders are basically worth 2 crores. Unsecured.
Yes, yes. Unsecured creditors, that is the fact is that
they are worth 2 crores. The amount is 2 crores.
yes, amount is
Total
worth of 2 crores.
2 crores.
And shareholding consent affidavits of for 75%. 25% was holding by the Senior Limited.
Okay.
So we can note down it this also. So it will be easy for us to give the answers.
That is one.
And another facts are this one. The name is being changed, main object clause is being changed, and authorized capital of the both the companies are being combined. So these are the 3 important changes. Then further, the transferee company, that is the Senior Limited, wants to reduce its paid-up capital, and another one is he wants to buy back. It wants to buy back its shares also. So reduction of capital is also there. Buyback of shares is also there. And swap ratio, that we understand that instead of the old shares, new shares will be issued by the transferee company. Now transferee company is holding 25% shares. So transferee company wants to create a trust and transfer its holding to that trust so that new shares can be issued to the transferee company also. So now is it clear right now? Or we will discuss during the question answers? First MCQ is, what is the jurisdiction for filing applications for approval of scheme of arrangement? Can joint application be filed? These are the 4 choices. A, B, C, D. Adjudicating authority, Mumbai for both companies. Yes. Yes is the for the joint application. NCLT Delhi for both the transferee company is in Delhi. As transferee company is in Delhi. Yes. NCLT Mumbai and NCLT Delhi for transferor company and transferee company respectively. Answer of second is no. Adjudicating authority Delhi for transfer company and transferee company, and then no. Which
B,
is the
B.
suitable answer?
B.
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 NCLT Delhi for both both as transferee company is in Delhi, and
Yeah.
joint application can be filed. Is it?
That's
Anyone
what-
else? Anyone else? So should I answer it?
Yeah, please.
Should be
Answer
C, I guess.
C.
Should be C.
Answer is C. Application is to be filed according to the jurisdiction of the company. The jurisdiction is as per the registered office that we know. So NCLT Mumbai and NCLT Delhi for transfer company and transferee company respectively. And joint application cannot be filed because application is to be filed before two NCLTs. If application is to be filed before one NCLT, then only joint application can be filed.
But eventually the decision will be taken at one place. It will be clubbed. While considering the case, it
No, that
clubbed
will be
and
afterwards. That will be afterwards, not in the initial stage.
and
Application is to
afterwards
be
it will
filed
be clubbed. Afterwards
Huh.
it will be clubbed.
for both the motions application. First stage and second stage are to be filed separately. And when the order of one NCLT will come, then the final order will come.
Okay. That means final order will be from the clubbed NCLT jurisdiction, no? Delhi.
Suppose a transfer company NCLT will give the order that it's okay, it can be merged.
Okay.
Then we'll give the copy of that order to the transferee company because finally the order will come from them. So then the final order will come. Okay.
Oh.
Second MCQ is
Which are the relevant sections here for this?
section 230. It starts from section 230 of the Companies Act, and 230 from 230 to 240. There is a separate chapter of compromise, arrangement, and amalgamations. So for most relevant sections are section 230, 231, and 232. Most relevant sections are these. Now, second MCQ is, can reduction of paid up share capital in the scheme is allowed? Yes, allowed. Not allowed as provisions of section 66 of CA 2013 required to be complied with. Yes, after filing separate application for this, none of the above.
Yes, allowed.
Yes, allowed. Anyone? Anyone else can try?
And there are many company secretaries also in the group. They must answer these questions.
So as per section 230, subsection 12 explanation, reduction of paid up share capital in the scheme is allowed. Okay. Now the third MCQ is, because we have seen reduction of capital is also there, buyback of shares is also there. So I've just framed separate questions on this.
Can you go to number 2 again?
Reduction of paid up share capital. Because transferee company has proposed reduction of paid up share capital. Is it okay? So it is allowed under the scheme of merger also that a company simultaneously can apply for the reduction of paid up share capital.
For the merged entity.
Yes. In the application itself, it has to be mentioned in the application.
Okay, that means that is covered in the scheme of amalgamation itself.
Yes, in the scheme of amalgamation itself. Third one is, can company buy back its shares under a scheme of arrangement without following the conditions prescribed under the Companies Act 2013? We know that there are separate provisions of reduction of share capital. There are separate provisions of buyback of shares under the Companies Act. So accordingly, this question was framed.
Okay.
Buyback of shares under the scheme, is it allowed or not?
C. Answer is C. Yes, with permission from members.
Anyone else can
No.
try?
No, madam.
No, yes,
Not
C,
allowed.
C. It's a C.
Maximum answer is C, but
B,
the
B.
correct answer is B. That is under section 230 subsection 10 of the Companies Act. It is specifically denied that buyback of its shares cannot be done under the scheme of amalgamation.
But when IBC is in picture, that code is in picture. That means under IBC, because that is a superior provision, superior law, no?
No, we are right now studying the compromise arrangement under the Companies Act. We have seen the nexus. So after that, we'll discuss something about the IBC code also.
Here, right
under
now we
IBC.
are discussing. Right now we are strictly within the Companies Act, purview of
Yes.
Companies Act.
Yes.
Sir, Gupta ji. Sir,
बोलिए चक्रवर्ती जी, बोलिए.
Sir, it will be better if Madam opens Companies Act, Bar Act, like you open on this other screen and teach us, sir.
Okay.
If she opens Bar Act, Companies Act and reads the sentences from that Bar Act while she teaches this, it will be better for us, sir. Like you are doing. Because we are totally new to Companies Act. Some of us are new to Companies Act, sir.
No, that is true. So I don't know whether madam is comfortable doing it right now or not.
It will not be possible
But
for me
what
to
you can
open.
do is you can go to my website.
I can read the provision for you. That is possible.
बस
That will be sufficient.
That is
That will
sufficient,
be
madam.
okay first.
That
Yes.
is sufficient, madam. हाँ जी.
Yes. It's section 230 subsection 10 that no compromise or arrangement in respect of any buyback of securities under this section shall be sanctioned by the tribunal unless such buyback is in accordance with the provisions of section 68. So under 68, it is a separate application is to be filed. Then MCQ 4. Is there any compromise and arrangement under the scheme?
No.
हमारी जो स्कीम थी, whatever we have discussed in the scheme, उसमें कुछ compromise और arrangement था क्या?
Yes, there is a compromise, no?
No, there's no.
No. B is the answer, madam.
B is the answer. Right. It's section 230, subsection 2, because all the amalgamation, mergers, etc. comes under compromise and arrangement only.
Okay.
Please read the
And
provision.
MCQ 5 is, can NCLT accept the application and proceed for directions? We have just seen that application was filed, consent affidavits was given, and one CA certificate was not attached with the application. So in such case, can NCLT accept the application and proceed for directions? Yes.
I think it
B
will
should-
answer will
B
be
should
B.
be there.
B. No, as it is incomplete.
So we'll ask to attach more documents
More
as
document.
required.
Yeah, correct.
Right, correct. So this is the answer is B under section 230 subsection 7 proviso. An auditor certificate is not provided. So whenever there are any defects in the documents, then NCLT gives us the chance to complete the documents.
Correct.
So it's generally 7 days time given for the correction of the defects.
Correct. Madam, one more thing. This 230, 240, this exact provisions which are basically covered in this IBC curriculum for the exam.
Yeah.
Are they available on the website of IBC or for Companies Act, or they have to be procured separately?
No, Companies Act, full Companies Act is covered. So this section and this chapter is specifically covered. Compromise, arrangement and amalgamation is specifically covered. And under this chapter, section 230, 231 and 230 is more important.
Okay. But can they be downloaded from the website?
You have to
Yes,
go to
yes.
MCA website.
Yes. MCA has the full ebook of the
Not-
Companies Act. Whatever you want to download, you can download.
No,
You
not
go to
from
MCA.
MCA. I'm asking about the IBBI website.
Yeah, IBBI is covered
So that
only.
whatever is covered under Arunji, 1 minute, I'm
Companies Act
asking
is there under in the IBBI site.
because IBBI will basically cover whatever is applicable for IBBI. No?
I don't think so. Companies Act is there in IBBI site. You can check it.
Okay.
Can NCLT grant dispensation of meeting of secured creditors in senior limited?
Dispensation of meeting of secured creditors.
So we have seen that 5 secured creditors,
Yeah. Yes, as all consent meeting.
consent affidavits. Should I go behind?
No, B is there. Answer is B.
Meeting is compulsory as resolution is to be passed with 75% majority of secured creditors.
Correct.
The consent
Answer is-
affidavit is there, then no need, no?
Yes, that is the correct answer. When consent affidavits are received, then there is no requirement of meetings. So NCLT has the power to dispense the meetings. So we have seen that 5 secured creditors were there and all have given their consent affidavits. So when consent affidavits have been given under section 230 subsection 9, 90% secured creditors consent is required. So if 90% in value of secured creditors consent is given, then there is the power is given to the NCLT to grant the dispensation of the meetings. So in this case, NCLT may grant dispensation of the meeting because all the consent affidavits has been received from the 5 secured creditors. The next question is, can NCLT grant dispensation of meeting of unsecured creditors in senior limited? Yes, as the net worth of the company is more than liability, so the company is capable to pay all its liabilities. Meeting is required as no consent affidavits received.
Madam,
It
what
should
do you
be
mean
A.
by grant dispensation?
Suspension means meeting is not required to be held.
66% they already have these. Na 66% only
No,
two.
don't relate it with the IBC 66%. That is not the case here. We are just studying the Companies Act.
It should be A.
Should be A. Anyone else?
It's B. B.
B.
Yes.
Yes.
It is
The
B.
correct answer is B. The same thing that we have just studied about the secured creditors, that 90% in value consent affidavits is to be received, then only the NCLT will grant dispensation of meeting. So in this case, we have not received any consent affidavits from the unsecured creditors, so no dispensation of meeting will be granted. Can NCLT grant dispensation of meeting of shareholders in senior limited? We have just seen that senior limited has 500 shareholders. So can the meeting will be dispensed? Yes,
No.
can be granted. No, section 230 talks for dispensation of creditors meeting only.
Yes.
So answer will be A or B?
B. B.
B. B, yes. So section 239 just speaks about dispensation of meeting of the secured creditors. But I'll just tell you one thing, that in certain cases, NCLT is granting dispensation of meeting on the basis of the NCLT and Supreme Court judgment. I have also taken a dispensation of shareholders meeting in a listed company on the basis of the net worth and all these things. So we have to present in the scheme itself in the way that NCLT can grant the dispensation of the
Any
shareholders.
company,
But
madam,
as per the law, this is not being granted.
but ma'am, in general, if we look into in any company, in a company when such level of decision is to be taken, obviously it has to be passed through a special resolution. The majority of shareholders has to approve it.
That's why, because after
Right.
the NCLT gives direction to hold the meeting, then only shareholders meeting are being held, not before that. Because
See, that's what
company
I'm
is
telling
to
you.
file the application before the NCLT for the directions to hold the meetings of shareholders, secured creditors, and unsecured creditors. So then only meetings is being held, not before that.
Correct.
So shareholders will give their consent in the meeting only.
Meeting.
Next MCQ is, can NCLT grant dispensation of meeting of unsecured creditors in junior private limited? Yes, as the consent affidavit of 9 unsecured creditors out of 10 has been received, being 90% creditors, meeting is compulsory. C, no consent affidavits received having value of 66.66% only. None of above.
A. Answer
Anyone
is A.
else?
C. C.
Very
Should I give
clearly,
answer?
because majority of present has to approve it.
C.
Na?
C is the answer.
90%. Answer is A.
90% should be there. no?
Value, not numbers.
Yes. Go ahead.
C
So
is the
answer is C. No, NCLT can't dispense the meeting of unsecured creditors because consent affidavits received having value of 66.66% only. Just in the previous questions, we have just discussed that 90% in value, not in numbers. So we have to take care of these things, that value of 90% is to be seen, not the numbers. Clear?
clear.
So next MCQ is, can NCLT grant dispensation of meeting of shareholders in junior private limited? Yes, consent affidavit of all outside shareholders received. We have just seen that only the consent affidavit of senior limited has not been given, who is holding 25% shares. Okay, so keep that in mind. And B is, meeting is to be held as not received consent affidavits of all. C, 9 shareholders consented out of 10, so it can be dispensed being 90%. None of the above.
A.
A.
B.
Anyone else?
That's outside. B is B.
Yes.
B.
It's B.
B.
Yes.
The correct answer is B. All consent affidavits required so that NCLT can use its power. Under NCLT rules, under Rule 11, NCLT has the inherent powers. Okay?
But provided 100% shareholders agree.
Yes. नहीं inherent power है, तो जब हमको consent affidavit मिल गया सब shareholders का, it means all shareholders has passed the resolution. So NCLT can dispense the meeting.
And what about in the case of class of shareholders?
Class of shareholders is under this IBC only, not under the Companies Act.
No, but here we are talking about NCLT. Acha. You are talking about a Companies Act.
Yeah, we are talking about Companies Act. So there is no such provision of class of creditors under the Mergers and Amalgamation in Companies Act.
Okay.
So in to use the inherent power by the NCLT, it is required that if consent affidavit of all shareholders has been received, then it can grant the dispensation. Clear? Next question is, which amongst the following is a restriction on senior limited in event of merger or amalgamation? Hold any shares in its own name, hold any shares in the name of any trust on its behalf, none of the above, all of the above. Under the facts, we have just seen that senior limited holds 25% shares in junior private limited, and it wants to transfer those shares to a trust so that under the swap ratio, shares can be issued to the trust. So that is the fact regarding this. So keeping that in mind, just answer this question.
A. Answer is A.
Hold any shares in its own name.
Its own name.
Hold any shares in the name of any trust. None of the above, all of the above.
All of the above.
All of them.
Can hold shares. So I'll just see 232 3B.
So they can continue to hold the share in its own name also.
Yes.
I have shared in the group also the text of the sections 230 to 240.
Okay.
So those who do not have a copy of the Companies Act, so they can see it from the WhatsApp group. You can just click on it and it will be open. On my website, all the
The
acts are
provision is-
available.
And
The
everything is
provision
there
is-
in your website.
Yes, yes.
I just read it out. Provided that a transferee company shall not, as a result of the compromise or arrangement, hold any shares in its own name or in the name of any trust, whether on its behalf or on behalf of any of its subsidiary or associate companies, and any such share shall be cancelled or extinguished. आप अपने नाम से भी होल्ड कर लो, चाहे ट्रस्ट के नाम से भी होल्ड कर लो, आपके शेयर्स एक्सटिंग्विश ही होंगे, कैंसिल ही होंगे. No swap ratio will be issued in regarding such shares. Next question is, can the transferee company change its name and objects under the scheme? Yes, allowed. No, all provisions of the Companies Act are to be complied with first.
Yes, it is allowed.
Yes, it is allowed. Anyone else? So that is the correct answer. Change in the name and object is allowed under the scheme.
Is allowed.
Yes. Next, can the authorized share capital of the transfer company be added to the authorized capital of the transferee company without paying additional fees as required under the Companies Act 2030? Because under the scheme, in this scheme, both the company's share capital, authorized share capital, not the paid up, authorized share capital is being merged, that is being added. So can it be done without paying additional fees? Option is the transferee company is not required to pay fees on increased authorized share capital as per fee schedule as it is allowed. B is the transferee company required to pay fees on increased authorized capital as per fee schedule then allowed. It is the discretion of concerned RD and ROC. D is none of the above. What is to be
B.
done in this case? Can
B.
it be allowed or not?
B.
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 B. Two required to pay.
Required to pay.
Yeah.
No, not
It's A.
required. A.
A. So the
A.
correct answer is A. As
A.
per section 232, subsection 3, clause I, the transferee company is not required to pay fees on increased authorized share capital. What is the logic behind that? Because the transfer company has already paid the fees on that authorized capital. So whenever we incorporate the company or increase the capital, then we have to pay the fees to the MCA on the authorized capital, increased authorized capital. So further fees is not required to be paid. Should I read this section 232(3)?
Yes, madam. Yes, madam. Please read all
this is-
section.
Yes. Where the transfer company is dissolved, the fee, if any, paid by the transfer company on its authorized capital shall be set off against any fees payable by the transferee company on its authorized capital subsequent to the amalgamation. So whatever fees has been paid by the transfer company, that will be adjusted against this increased authorized capital of transferee company. So no further fees is required to be paid. I think now it's clear. The next question is the appointed date given in the scheme is allowed and maintainable? Yes, it is the discretion of the company to fix appointed date. The appointed date should be the date on which NCLT passed order of merger. If appointed date is predated by a year or more from the date of applying with NCLT, justification should be provided for the same in the scheme, and D is none of the above. We have seen that appointed date was 1st October 2019. Scheme was filed in 2021.
2021 when?
In April 2021, scheme was filed for the appointed date 1st October 2019. Is it clear to you what is appointed date?
No, not clear.
Appointed date is the date from which the scheme of merger will be effective.
Okay.
Practically,
Okay.
there are two concepts, appointed date and effective date. Effective date is the date of the order and further filing with the ROC. And appointed date we can keep in the scheme itself, that appointed date will be this one. So now the rule is that I'll just give the answer. This is C. If appointed date is predated by a year or more from the date of applying with the NCLT, justification should be provided for the same in the scheme. What NCLT has given in this circular dated 21st August 2019, that if appointed date is predated by a year or more, then justification should be given, otherwise it will not be accepted by the NCLT. So generally NCLT is saying that appointed date should be within a year only.
Okay.
Otherwise reason must be given. This is as per this circular dated 21st August 2019. So from the appointed date only, the accounting purposes, for the accounting purposes, the balance sheets are being merged for both the transfer company and transferee company after receiving the final order of the NCLT. Is it clear?
Clear.
Yeah.
Next question is, the swap ratio decided was on the basis of valuation of shares on the basis of book value, valuation of shares done by registered valuer, valuation of shares done by merchant banker, valuation of shares done by a chartered accountant.
D.
C.
C.
Merchant banker.
Merchant banker.
B. Registered valuer.
Yes,
B,
the answer
registered.
is B, that is registered valuer. Now onwards, all the valuations are to be done by the registered valuer only. Previously, it was merchant banker or chartered accountants, but now registered valuer is to be authorized to do all the valuation. So this is the first part of the MCQ that we have seen the basic procedure points of the mergers, that meetings, how can it be dispensed with, what can be incorporated in the scheme only, that reduction can be incorporated, buyback cannot be incorporated, like that. Now second part, just think that senior limited is a holding company and junior private limited is a wholly owned subsidiary, and consent affidavit of shareholders as well as unsecured creditors of junior private limited was provided with the application. In previous case, we have seen that all the consent affidavits have not been given, only 9 consent affidavits have been given. So in this case, what can be done? This is a separate one, holding company and wholly owned subsidiary relationship is there. And consent affidavit of shareholders as well as unsecured creditors of junior private limited was provided with the application only. It is submitted that there are no existing commitments, obligations or arrangements by the transfer company. No new shares are being issued by the transferee company and the scheme would not result in dilution of the shareholding of the transferee company. No consideration as being WOS. जब होल्डिंग और सब्सिडरी कंपनी होती है, होली ओन्ड सब्सिडरी कंपनी होती है, तो उस केस में क्या होता है कि सारे के सारे शेयर्स होल्डिंग कंपनी होल्ड करती है सब्सिडरी कंपनी की.
Correct.
So there is only one shareholder practically. NCLT ordered meetings of shareholders and unsecured creditors of senior limited. Notice of the meeting were given to all shareholders, creditors, RD, ROC, OL, SEBI and stock exchange. All meetings of junior private limited were dispensed with. Meetings में क्या होता है, जब NCLT order करती है, at that time NCLT gives the order that give the notice of meeting to all the authorities like RD, ROC, OL, SEBI and stock exchange. If the company is listed, then SEBI and stock exchange also. In the meeting of unsecured creditors of senior limited, out of 70, only 16 persons were present. So we have seen that junior limited meetings were dispensed with. So to make it simple, I just keep it like this, that junior private limited, all meetings were dispensed with. Now we have to concentrate on the senior limited only. In the meeting of unsecured creditors of senior limited, out of 70, only 16 persons were present and only 12 persons voted in favor of the scheme and 4 persons abstained from voting. And out of 500 shareholders of senior limited, only 50 persons attended physically shareholders meeting and 42 shareholders voted in favor of 8 persons against it and 8 persons against it. So this is the case Out of 70, only 16 persons were present and 12 persons voted in favor and 4 abstained. And in the shareholders meeting, only 50 persons were present and 42 shareholders voted in favor and 8 persons against it. So this is the fact. The chairman and scrutinizer for the meetings were appointed as suggested by the applicant companies. No remuneration was fixed by NCLT. देखिए, few facts may be given in the case study, which may be relevant and which may not be relevant to the MCQs. So keep this in mind while answering the case studies. All the meetings held and documents filed with NCLT, if after the procedure the NCLT passed final order of approval on 16th July 2021, for which copy was received on 18th July 2021. The same was filed with the ROC on 10th August 2021. The implementation period of the scheme is to take around 1 year, and the company is to file statement of implementation with ROC within prescribed time. So ये फैक्ट क्लियर हुआ आपको? एनसीएलटी ने फाइनल ऑर्डर पास किया 16 जुलाई 2021 को, कॉपी उसकी रिसीव हुई 18 जुलाई 2021 को, और आरओसी में उसकी कॉपी फाइल करी गई 10 अगस्त 2021 को, और इम्प्लीमेंटेशन पीरियड रखा गया 1 साल के अराउंड. नाउ इस पे बेस्ड कुछ एमसीक्यूज है ताकि अपने को ये चीजें भी क्लियर हो जाए. Meetings of transfer company was dispensed with on the basis of, as the transferee company was holding so only one shareholder, as the consent affidavits was received and NCLT has discretion to dispense meeting, none of the above. हमने देखा ट्रांसफर कंपनी के सब मीटिंग्स डिस्पेंस विद कर दी थी, तो किस ग्राउंड पे डिस्पेंस हो सकती है?
Consent affidavit.
Consent affidavit. So answer is B, consent affidavit. अब यहाँ एक पॉइंट जो ध्यान देने वाला है वो ये है कि only one shareholder was there in the transfer company, that is the senior limited transferee company. But even though the scheme is of senior limited and junior limited, both are holding and subsidiary. In fact, in such situation also, the senior limited or the transferee company has to give the consent affidavit to the NCLT to get the dispensation of meetings. Clear? Next question is whether shareholders resolution is deemed to be passed. हमने देखा था 42 shareholders ने फेवर में वोट किया था, 50 shareholders present थे. So accordingly, you have to give the answer. A is yes, as voted by 42 shareholders in favor out of 50 shareholders present in the meeting, comprising more than 75%. B, no, as 450 shareholders not attended meeting, which is more than 75% of total shareholders. No, as 8 shareholders voted against it, which is 16% of the total shareholders who attended meeting. None of the above.
It's A.
A.
It should be A.
Yes, it is voted by 42 shareholders, which is
Basically,
out of
those
50
who are
shareholders.
present matters.
Yes, only the shareholders who are present in the meetings matters, not the
Okay.
450 shareholders who have not attended the meeting is irrelevant for this case. Next question is whether unsecured creditors resolution is deemed to be passed. As 4 creditors abstained out of 16 from voting, consisting 25% of total attended the meeting. Yes, as 75% voted in favor out of total present. No, as only 16 creditors attended meeting out of 70, which is less than 75% creditors. Yes, as 100% votes are in favor.
It's B.
It's B.
Yes. It's B.
Anyone else? It's B. As per section 236, 3/4 majority has to pass the resolution. So 75% voted in favor out of total present. So here also the presence of the creditors is important, not the total number of shareholders. Yes. Next question is whether chairman and scrutinizer of the meeting suggested by the applicant can be appointed. only NCLT has to finalize the name of chairman and scrutinizer of the meeting at its own. NCLT can appoint as suggested by applicant. Only court persons are to be appointed or none of the above. Who has to appoint chairman and scrutinizer? Because in the meetings directed by the court, chairman and scrutinizers are to be appointed. Chairman will chair the meeting and scrutinizer will give the decision, will give the details of the voting.
NCLT B. NCLT can appoint as suggested by applicant. No, C. Answer is C.
Answer is
It's
C.
none of the above.
None of the above. This is a practical question. So just that's why I kept it in this. What happens in such cases? NCLT has to appoint the chairman and scrutinizer in its order. But NCLT can appoint as suggested by applicant.
B will be the answer.
So B will be the answer. Correct. Next question. Within how many days copy of NCLT order is required to be filed with ROC? We know that all order copy are to be filed with the ROC. So 60 days from
Ma'am, one thing in the just 1 minute sorry for interruption. In the last question, where you the answer was that NCLT. Can you go back onto that? Yeah, NCLT can appoint as suggested by applicant. In case suppose NCLT does not want to appoint the one suggested by applicant because it is can. The word you are using can. Then in that case, what happens?
Then NCLT can give the name of any other person.
That NCLT basically has to suggest that.
Yes.
That board will suggest.
But in 99% cases, NCLT is appointing whatever is suggested by the applicant.
Okay.
Practically.
Because they basically want to expedite everything.
Yes, they want to
That is the
expedite.
idea of IBC. Huh?
And generally what happens, the proposed person is of the local, generally.
Okay.
So it becomes easy for the company to conduct the meeting and to give the order because there is a time management also. Within 7 days, we have to give the chairman's report. We have to file it with the NCLT. All the procedural aspects becomes easy then.
Okay.
Within how many days copy of NCLT order is required to be filed with ROC? 60 days from 16th July. That is, we know that 16th July, the date of order passing by the NCLT. 30 days from 16th July, that is date of passing of order. 30 days from 18th July, that is date of receipt of certified copy of order. 60 days from 18th July, that is date of receipt of certified copy of order.
C.
So within how many days we have to file it with the ROC? Such type of questions are being asked in the IBC course also, IBC exam also.
C, madam.
C, it is C. Date of the receipt of the certified copy of the order.
Yes, the answer is C, as per section 238. I just referred the sections also for the convenience of the participants, so you can read that particular section and subsection also. Next question is, what is effective date in this case as NCLT order passed on 16th July and order filed on 10th August 2021 with ROC? What will be the effective date? Anyone can answer?
16th July, order received from the NCLT.
That is the date of order passed by the NCLT, 16th
Yes.
July.
Yes.
And filed with the ROC on 10th August. Appointed date was 1st October 2019 and 18th July was the date of receipt of the copy of order.
No, madam, 16/7 only, madam. Order passed.
Effective
But
date
the
will be
moment order
16th.
passed, it becomes effective.
Order passed date.
Order passed date.
No, it is when order was filed with the ROC.
Oh.
So that is the effective date. Once the order is filed with the ROC, then the total process is complete and that will be the effective date for the purpose of mergers and amalgamation.
Okay.
So that
means when officially
what happens,
received the
because we have the 30 days time period to file the NCLT order with the ROC. So when the order is filed, then only that is the date of effective date. In the scheme itself, we just define the effective date, and effective date is the date of filing of the NCLT order with the ROC.
ROC.
Yes. So next question is, after scheme being effective, what is required to be filed by the company with ROC? Statement of all assets and liabilities. Suppose scheme हो गई, order हो गया, ROC में file कर दिया हमने, ठीक है, effective date भी हो गई. अब after that, what is to be done by the company? Statement of all assets and liabilities of the transfer company, statement of deviation from the scheme, statement of implementation of the scheme, none of the above.
C.
Yes, that is the C. Answer is C. As per section 232, subsection 7, statement of implementation of the scheme is to be filed with the ROC. इसका मतलब क्या हुआ कि हमने स्कीम में बोला था कि we will issue the shares, swap ratio होगा, allotment होगा, या स्कीम में कुछ लैंड एंड प्रॉपर्टी है जो ट्रांसफर होगी. So whatever is in the scheme, उसका implementation कहाँ तक हुआ, that we have to file it with the ROC. ओके, सो जब तक नहीं होता है तब तक हमको ये फाइल करना रहता है. The transfer company will be dissolved without winding up. Yes, as per the provisions of section 232 of the Companies Act, or further procedure are required to be followed as per winding up rules.
Yeah.
Anyone
Yeah.
else?
Yeah.
Anyone else will try?
It's A.
Yes, it's A, that as per the provisions of section 232 of the Companies Act, the transfer company will be dissolved without winding up procedure. So these were the question answers. Now I just want to give some reference cases of WOS merger. WOS means wholly owned subsidiary. Practical case. What happened in the practical case? In the application, it was prayed to dispense the meeting of shareholders and creditors of both the companies. Because an application was filed with the NCLT, and it was prayed that to dispense the meetings of shareholders and creditors. It was submitted that under the scheme, there is no compromise or arrangement with the shareholders. Compromise means any compromise is to be done by the creditors. Okay, hence the scheme would not prejudicially affect the creditors or shareholders of the applicant company. This is a practical case, so that I just want to refer this. The only objection taken by the learned NCLT that no written consent affidavit by way of affidavit of the shareholders and creditors were filed. Okay, in this case, the objection taken by the NCLT that no consent affidavit was filed and suspension of meetings was prayed on the basis of this, that it will not prejudicially affect the creditors or shareholders. This is the case of Dirk India Limited versus Ambuja Cement Limited. NCLT Ahmedabad has rejected the application to dispense meeting of transferee company, and order was challenged in NCLT, who allowed it. इसमें क्या हुआ था, मीटिंग का डिस्पेंशन नहीं दिया एनसीएलटी अहमदाबाद ने, तो उन्होंने मैटर को चैलेंज कर दिया एनसीएलटी में, और एनसीएलटी ने उसको अलाउ किया. क्या ग्राउंड था? ग्राउंड था that the net worth of the transferee company is highly positive and sufficient to meet its obligations. During the MCQ, I just told you that and practically NCLT can allow the suspension of the meeting as per its inherent power under Rule 11 of the NCLT rules. And in this case, net worth of the transferee company is highly positive. It was the case of wholly owned subsidiary. There was no change in the shareholding pattern. So it can be allowed in such cases. There is no impact on shareholders as well as creditors. So transferee company, so it can be allowed by the NCLT. So NCLT allowed in this case after the rejection of NCLT. So after that case, NCLT has also started allowing such type of cases. यहाँ पर मैं एक चीज आप लोग को ध्यान दिलाना चाहूंगी कि NCLT next line में पढ़ती हूँ, then we'll discuss. Though allowed in Vodafone case by the same NCLT, which is contrary to the principle of judicial discipline, as precedent law must be followed as per Supreme Court judgment in Gammon India Limited 2011. The tribunal NCLT Ahmedabad bench erred in not following its own order passed in Vodafone Idea Limited, wherein similar facts are involved in both the cases. क्या हुआ था, वोडाफोन आइडिया में इस ग्राउंड पर डिस्पेंशन ऑफ मीटिंग अलाउ की गई थी, एनसीएलटी अहमदाबाद ने ही अलाउ की थी. तो इट बिकम अ प्रेसिडेंट, and when once NCLT Ahmedabad has allowed such suspension, it cannot reject such suspension in the same case again, because this principle of judicial discipline has been given by the Supreme Court in the Gammon India Limited. Is it clear? हेलो
जी क्लियर है.
क्लियर है ना. वोडाफोन में उन्होंने दिया था डिस्पेंशन, लेकिन अंबुजा सीमेंट वाले केस में नहीं दिया, इसलिए वो एनसीएलटी में चले गए. तो इसका मतलब यह वोडाफोन वाले केस में दिया था तो उनको दूसरे केस में भी देना चाहिए था, बिकॉज ये उनका खुद का ही प्रेसिडेंट था. और एज पर द सुप्रीम कोर्ट रूलिंग दे कैन नॉट ओवरराइड देयर ओन रूलिंग. डिफरेंट ऑर्डर नहीं दे सकते. अब जो मैं बता रही हूँ ये अपन सिर्फ इंफॉर्मेशन के लिए डिस्कस कर रहे हैं. अभी अपनी केस स्टडी ऑलमोस्ट ओवर है. इसमें कुछ मैंने क्वेश्चन आंसर्स बनाए हैं, बट ये मोर फॉर अंडरस्टैंडिंग. The restructuring proposals involving amalgamation or reconstruction, including demerger of a company, needs to comply with the process set out under the provisions of section 230. हमने देखा कि 230 और 232 of the Companies Act में जो provisions हैं, जो merger framework बनाया गया है, we have to follow those provisions for the mergers and amalgamations. So prior approval of creditors, secured creditors, unsecured creditors, meetings of the members, all these things are there, है ना? That is to be approved by the NCLT. Now, अभी question आता है कि whether a resolution plan proposing restructuring of a corporate debtor would need to comply with the merger framework after such resolution plan has been approved by the adjudicating authority in terms of the provisions of the code. अभी हम यहाँ linking कर रहे हैं कि हमने resolution plan में एक restructuring है, तो is it required to comply all the merger framework? Can anyone give any view? This is just for reference.
I think it is not required because
Yes, it is not required actually.
Yes, it is not required. The answer is given like this. Under the provisions of the code, a resolution plan requires approval of the COC. Okay. COC comprises generally the financial creditors of the corporate debtor. Okay. So the resolution plan, once approved, it becomes binding on all the members or creditors. Okay. Are in terms of explanation to section 30 subsection 2 of the IBC code, it is prescribed that if any approval of shareholders is required under the Companies Act or any other law for the time being in force for the implementation of the actions under the resolution plan, such approval shall be deemed to have been given and it shall not be a contravention of the Companies Act or law. So in view of this deemed consent of shareholders and the resolution plan being binding upon the creditors, it is argued that where the resolution plan contemplates a restructuring of the CD by way of merger, amalgamation or demerger, then corporate debtor is not required to comply with the merger. So here section 30 subsection 2 of the code is important, which already gives that if approval has been taken by the adjudicating authority under the resolution plan, then separate approval is not required. So I just wanted to point out this particular provision. Then second question is whether the resolution applicant would need to comply with the merger framework, which stipulates the requirement of prior approval of the creditors and members before the scheme of amalgamation can be approved by the NCLT. If the resolution plan proposes merger of the corporate debtor with the resolution applicant, particularly in view of the fact that section 31 subsection 4 of the code requires the resolution applicant to obtain necessary regulatory approvals within a period of 1 year from the date of approval. तो इसमें क्या व्यू बनता है आपका? सेक्शन 31 सबसेक्शन 4 ऑफ द कोड आप लोगों ने पढ़ा होगा, उसमें ये दिया है कि ये नेसेसरी अप्रूवल्स जो भी होंगे वो विद इन अ पीरियड ऑफ 1 ईयर लेने हैं. ठीक है, तो इसका रेफरेंस मैं आपको यहाँ बताती हूँ. The resolution applicant acquires complete control and ownership of the corporate debtor, okay, pursuant to the implementation of the resolution plan. So as a result, CD becomes a subsidiary of the resolution applicant. Some cases wholly owned subsidiary बन जाती है, some cases में subsidiary बन जाती है, some cases में otherwise भी रहती है as per the resolution plan. The liabilities of the corporate debtor are also restructured substantially and paid off pursuant to the resolution plan. So in such case, amalgamation of the CD with the RA might not be adversarial to the interest of the creditors and members of the RA. So the resolution applicant should not be required to comply with the merger framework separately once the resolution plan is approved by the AA. तो हमने क्या देखा कि कंपनीज एक्ट में मर्जर्स एंड अमालगमेशन का एक सेपरेट फ्रेमवर्क है, एक सेपरेट कंप्लायंस है, एक सेपरेट प्रोसीजर है, ऑल डिफरेंट प्रोविजंस है. पर जब हम इसको आईबीसी के केस में देखते हैं तो आईबीसी में चाहे सीआरपी में हो चाहे लिक्विडेशन में हो, इन बोथ केसेस मर्जर्स एंड अमालगमेशंस आर अलाउड. सो इन दोस केसेस द सेपरेट अप्रूवल्स आर नॉट रिक्वायर्ड.
Not required.
Because what is the logic behind this? The objective of the code is to consolidate and amend the laws relating to insolvency and reorganization of corporate persons and matters connected therewith or incidental thereto. And in the case of Innovative Industries Limited, it is settled law that a consolidating and amending act like the present central enactment forms a code complete in itself and is exhaustive of the matters dealt with therein. So as per these provisions, the separate approvals are not required. Next, मैंने एक प्रैक्टिकल केस लिया है जिसमें अमालगमेशन और मर्जर आईबीसी के केस में इन्वॉल्व था. वो है अपना मोनेट स्पात एंड एनर्जी लिमिटेड का, MIEL का. इसमें मर्जर का प्रपोजल था आईबीसी में रेजोल्यूशन प्लान में. सो दिस इज फॉर आवर नॉलेज कि कैसे आईबीसी के केसेस में या रेजोल्यूशन प्लान में मर्जर के केसेस इनकॉर्पोरेट किए जाते हैं. शुड आई गो अहेड? डू आई हैव टाइम?
Yes, madam. Please.
Yes, please. Yes, please.
Go ahead.
Yes, please, please.
Yes, yes.
Because
So we have
through
just
practical examples alone, members will be able to appreciate.
Yeah, this is
things
a very
better.
practical example
Yes, yes.
already held.
Haan ji.
So we all know that 12 companies were identified by the Reserve Bank of India in the year 2017 for the insolvency proceedings. So out of that, Monet Spath and Energy Limited was one of them. So State Bank of India has filed a petition before the Mumbai bench regarding this Monet Spath and Energy Limited. And Mr. Sumit Binani was appointed as the resolution professional for this case. A consortium comprising of Aon Investment Private Limited and JSW Steel Limited, ये दोनों कंपनी ने मिलकर एक कंसोर्टियम बनाया और they were the only applicant as a RA. So letter of intent इन्होंने दिया और COC ने इसको अप्रूव किया कंसोर्टियम का RA resolution plan. Okay, and resolution plan was just approved orally and then कुछ changes भी उसमें किए गए थे. So written order of the NCLT was given on 24 July 2018 and resolution plan was approved and uploaded on the website of the NCLT on 25th July 2018. Generally, we know that order is being passed on the first day and order is being uploaded on the website after a few days or next day or anytime. So these are the dates. In this case, 24th July order was passed and 25th July order was uploaded on the website. Pursuant to the provisions of Regulation 30, read with paragraph 16K and I of Part A of Schedule 3rd of the LODR. Now, LODR is also in our course, that is listing obligations. I think you all are aware of this thing.
Yeah.
So according to this regulation, salient features of the resolution plan and other material informations are like this. कि ट्रीटमेंट ऑफ क्रेडिटर्स का क्या होगा, कैसे रिजोल्यूशन प्लान में क्रेडिटर्स को पेमेंट किया जाएगा. सो ये रिजोल्यूशन प्लान में बताया गया था. दिस इज एलाबोरेटेड हियर. पेमेंट कैसे किया जाएगा फाइनेंशियल क्रेडिटर्स को, एडमिटेड डेट्स को कैसे दिया जाएगा, क्या इफेक्टिव डेट होगी, इसको मैं शॉर्ट में ले रही हूँ क्योंकि मेन पॉइंट मेरे को जो बताना है वो डिफरेंट है. देन सेकेंड पॉइंट वाज कैपिटल इन्फ्यूजन इनटू द कंपनी. दैट रिजोल्यूशन प्लान के बाद में कितने कैपिटल इन्फ्यूज करेगा. MSL, a special purpose vehicle directly indirectly owned by members of the consortium. क्या हुआ था, कंसोर्टियम में जो दोनों कंपनीज थी उन्होंने एक स्पेशल पर्पस व्हीकल बनाया, दैट इज नोन एज MSL, फॉर द पर्पस ऑफ दिस रिजोल्यूशन प्लान. JSW Steel will provide INR 125 crore as a working capital advance to the company. और इन्होंने जो डिसाइड किया कि कौन कितना वर्किंग कैपिटल इन्फ्यूज करेगा. तो दिस इज अ पार्ट ऑफ रिजोल्यूशन प्लान. देन डिटेल्स ऑफ द स्ट्रक्चरिंग प्रपोजल फॉर एक्विजिशन ऑफ द कंपनी. थर्ड पॉइंट उसमें इंपॉर्टेंट था कि कैसे रीस्ट्रक्चरिंग करेंगे इसकी एक्विजिशन ऑफ द कंपनी की. That in accordance with regulation 37(7) of the LODR regulation. LODR में भी क्या है कि जो क्लॉज है, जो रेगुलेशन 37 है, उसमें ये कंपलसरी किया गया है कि the details of the restructuring proposal forming part of the resolution plan are set out below. Upon implementation of the resolution plan, the consortium will acquire control over the company on the effective date pursuant to the restructuring proposal proposed in the resolution plan, which involves the following. क्या क्या उसमें है? कन्वर्जन ऑफ पार्ट डेट इनटू इक्विटी. तो हमने अभी देखा था कि उसमें क्या क्या चीजें होती है. यहाँ पर ये कंप्रोमाइज हो गया, पार्ट डेट को इक्विटी में कन्वर्ट करेंगे. देन कैपिटल रिडक्शन, इस केस में भी कैपिटल रिडक्शन था. आफ्टर द कन्वर्जन ऑफ डेट इनटू इक्विटी देयर विल बी अ कंप्लीट एक्सटिंग्विशमेंट ऑफ द एंटायर इक्विटी शेयर कैपिटल हेल्ड बाय द एग्जिस्टिंग प्रोमोटर्स ऑफ द कंपनी. प्रोमोटर्स की पूरी कैपिटल एक्सटिंग्विश हो जाएगी और remaining paid up capital and subscribed equity share capital of the company held by non-promoter shareholders will be reduced on a proportionate basis to 33.06%. तो यहाँ पर जैसे हमने देखा था मर्जर की स्कीम में रिडक्शन ऑफ कैपिटल अलाउड है, वैसे ही रिजोल्यूशन प्लान में मर्जर की स्कीम भी अलाउड है प्लस रिडक्शन ऑफ कैपिटल भी अलाउड है. देन था मर्जर. मर्जर अलाउड है बिकॉज एज मेंशन्ड अबाउट MSL is a special purpose vehicle which has been set up and capitalized directly indirectly by members of the consortium. MSL को किसने पेमेंट किया था, किसने खड़ा किया? कंसोर्टियम ने. दोनों कंपनी मिलके एक MSL एज अ स्पेशल पर्पस व्हीकल उन्होंने बनाया था फॉर द मर्जर पर्पस. So in accordance with the resolution plan, MSL will merge with and into the company pursuant to which the equity and preference shareholders of MSL will be issued equity shares and compulsory convertible preference shares to the of the company in the following exchange ratio. मतलब उन्होंने मर्ज कर देंगे दोनों कंपनी को, MSL को, और केस किसका था? मोनेट इस्पात का. सो MSL को स्पेशल पर्पस व्हीकल को उन्होंने बनाया इसलिए था कि मोनेट इस्पात को बाद में इसमें मर्ज कर सकते, दोनों कंपनीज को मर्ज कर सकते हैं. और मर्ज करने में उन्होंने स्वैप रेशियो डिसाइड कर लिया था अकॉर्डिंगली. So ये मैंने डिटेल दी है. You can just study. I just want to show that in a resolution plan कितनी चीजें आ सकती है. इसमें एक resolution plan में कितनी चीजें हो सकती है. Reclassification of existing promoters into public and of the incoming shareholders as promoters. LODR में एक प्रोविजन होता है कि promoters और public shareholding अपने को डिसाइड करना होता है. We have to decide that these are the promoters. तो जब भी हम प्रोमोटर्स को रिक्लासिफाई करना चाहते हैं या प्रोमोटर्स कैटेगरी में से किसी को बाहर करना चाहते हैं या किसी और को प्रोमोटर कैटेगरी में इंसर्ट करना चाहते हैं, देन वी हैव टू फॉलो द वेरियस रेगुलेशंस ऑफ द LODR. सो इस केस में भी क्या हुआ था कि रिक्लासिफिकेशन हुआ था एग्जिस्टिंग प्रोमोटर्स का, क्योंकि वो तो बाहर हो गए थे. देन they were under the public category or new incoming shareholders has been classified as promoters. So this can be done under the resolution plan itself. Change in the board of directors of the company. कैसे board of directors को भी change हो जाएंगे कंपनी में. ये सारे important provisions resolution plan में impact किए गए थे. Sorry. यहाँ पर मैंने 2-3 questions रखे हैं सिर्फ just आपको elaborate करने के लिए. When the plan is required to be submitted to the stock exchange where the company is listed. Listed company को सारे important points को या सारे important documents को या सारे important informations को stock exchange को share करना होता है. तो यहाँ पर जब resolution plan बना तो this is also required to be submitted to the stock exchange. where the company is listed. तो किस डेट में उसको हमें स्टॉक एक्सचेंज को सबमिट करना है. The date approved by NCLT 19 जुलाई 2018. The date on which plan was uploaded on NCLT site 25 जुलाई 2018. Within a day after availability of website of NCLT, that is 26 July 2018, and within a day after approved by NCLT, that is 20th July 2018. This is the LODR provision regarding the resolution plan.
It is D. Answer is D.
Answer is B. The date on which plan was uploaded on NCLT site. Is it so?
Within a day
No,
approved.
D. Within a day after approval, approved by NCLT. That is 24
D.
hours के अंदर.
नहीं सर. This is
अच्छा, तो-
LODR provision में क्या है? ऑर्डर तो आपका 19 जुलाई को पास हो गया.
आप
Approved
बोल
by
रहे हो कि
NCLT.
एनसीएलटी की वेबसाइट में जिस दिन अपलोड हुआ उसके 24 घंटे के अंदर अपलोड करना.
Yes, NCLT की वेबसाइट पे कई बार होता है 15 दिन तक अपलोड ही नहीं होता.
Okay. But you tell me one thing. If suppose the date when the NCLT is approved,
हाँ.
so how they communicate to the CD and the RP.
Yes.
When they communicate through the website only, or they directly deliver it?
नहीं, ये ऑर्डर रिजर्व कर लेते हैं. जनरली एनसीएलटी में क्या होता है, ऑर्डर रिजर्व कर लेते हैं. तो वो
Okay.
हमें पता तो चल जाता है कि ऑर्डर इज अप्रूव्ड, रिजोल्यूशन प्लान इज अप्रूव्ड, पर जब तक डॉक्यूमेंट्स में नहीं आता है या ऑर्डर में नहीं आता है तब तक हम उसको किसी अथॉरिटी को नहीं पास ऑन कर सकते.
So that means the effective date has to be taken into consideration.
यस, तो जिस दिन हमको ऑर्डर अपलोड हुआ उसके एक दिन के अंदर हमको स्टॉक
Okay.
एक्सचेंज में फाइल करना होता है.
ठीक.
24 आवर्स का टाइम दिया गया हमें.
So from that date only.
हाँ, जिस दिन एनसीएलटी के साइट में अपलोड हो गया मींस पब्लिक हो गया वो डॉक्यूमेंट.
उसी से LODR के प्रोविजंस लग जाएंगे. 24 घंटे के अंदर आपको अपलोड
24 घंटे के अंदर आपको फाइल करना है.
करना. ठीक.
What is the full form of LODR?
या
What is the full form of LODR?
लिस्टिंग
ये
ऑब्लिगेशन एंड
listing of-
डिस्क्लोजर रिक्वायरमेंट्स रेगुलेशंस हैं ये
Thank-
सेबी के.
thank you.
लिस्टिंग ऑब्लिगेशंस, जो भी लिस्टेड कंपनीज होती है उनको लिस्टिंग ऑब्लिगेशंस कंप्लाई करना पड़ता है. उसमें बहुत सारे प्रोविजंस है, रूल्स एंड रेगुलेशंस.
And they are very strict about it.
Yeah, they are
thank
very strict about this. Corporate governance का हम बहुत नाम सुनते हैं आजकल. That is under this LODR only for the
LODR.
listed companies.
And virtually a company has to be on toes actually. Any listed company.
Yes. The company has to comply all the provisions.
All
and
the
that
provisions.
is day to day, quarterly, monthly, yearly,
Monthly.
half yearly.
Director
Everything is
removal,
there.
director appointment, anything.
Yeah, everything is being provided. अभी तो और strict होता जा रहा
Any
है.
KPR,
Yes.
movement, everything.
What is the corporate restructuring under the scheme? Conversion of debt into equity, reduction of share capital, both A and B, only A of the above. इस केस में क्या होता है?
A and B.
Corporate
It's B. Reduction of share capital.
C, madam.
Yes, C, both A and B. हमने देखा था इस स्कीम में कॉर्पोरेट रिस्ट्रक्चरिंग में क्या क्या था. डेट भी इक्विटी में कन्वर्ट हो रहा है, रिडक्शन ऑफ शेयर कैपिटल भी हो रहा है.
Correct.
ये
So A
दोनों
and B
रिलेटेड
both.
है कैपिटल से, तो रिस्ट्रक्चरिंग हो रही ना उसकी.
Correct.
तो both A and B, C is the correct answer. Third MCQ is it acquisition of a company? Yes or no?
Yes.
Yes, it is the acquisition of the company. तो जैसे हमने पढ़ा कि कंपनीज एक्ट में मर्जर फ्रेमवर्क हमको कंप्लाई नहीं करना पड़ता है अंडर द रिजोल्यूशन प्लान. अगर हमारा मर्जर का प्रोविजन है तो, अगर नहीं है तो हमको सेपरेटली कंप्लाई करना पड़ेगा. सम कंपनीज में क्या होता है, द कंपनी गिव्स रिजोल्यूशन प्लान ओनली टू टेक ओवर द कंपनी and after that they plan to merge the company. So in that case separate provisions are to be complied with as per the Companies Act. But if merger proposal is within the resolution plan itself, then no separate approvals are required. So this is clear now to everyone. Okay, I think so.
हाँ, बिल्कुल ठीक है मैडम. तो मैडम
ठीक है
वी
ना?
विल रिक्वेस्ट यू कि आप ना एक केस स्टडी ऐसी भी बना दीजिएगा कि रेजोल्यूशन प्लान से रिलेटेड, कि रेजोल्यूशन प्लान है और उसमें यू टेक योर टाइम कि रेजोल्यूशन प्लान में ये
Okay.
मर्जर सजेस्ट किया गया इस तरह से।
ओके सर।
ये एक बार दोबारा रिपीट करेंगे मैम, ये जो आपने अभी बोला, ये जो लास्ट
मैंने
सबमिशन था
बोला
आपका।
कि मर्जर एंड अमालगमेशन और हमारा जो नेक्सस है मर्जर्स एंड अमालगमेशंस का और आईबीसी का, वो हमने अभी देखा कि क्या नेक्सस है। जब रेजोल्यूशन प्लान में ऑलरेडी मर्जर और डीमर्जर और रिस्ट्रक्चरिंग हमने प्रपोज किया हुआ है, तो हमको सेपरेट अप्रूवल्स लेने की जरूरत नहीं होती है। सपोज ए और ए कंपनी ने रेजोल्यूशन प्लान दिया बी को टेक ओवर करने का, बी की डिस्ट्रेस्ड एसेट्स को टेक ओवर करने का, ठीक है। इन रेजोल्यूशन प्लान नो प्रपोजल वाज देयर ऑफ द मर्जर और अमालगमेशंस, ओके। देन कंपनी कैन टेक ओवर द बी कंपनी, okay. Then after 6 months or after 1 year or after say any time, the company proposes to merge both the companies.
Okay.
So in that case, separate provisions of Companies Act will apply.
Okay. That means they will be more treated under Companies Act at that point of time.
Yes, yes. Because resolution plan is over, company has taken
Correct.
over or had implemented the resolution plan, so no separate approvals are required.
और इवन मैडम मेरे हिसाब से, if my understanding is correct, liquidation में भी 90 days period is given for this compromise arrangements and amalgamations.
Yes, sir.
Okay.
And in that case also provisions of Companies Act have to be seen.
Yes, in liquidation also 90 days period is given for the,
क्योंकि participants will be able to relate with that thing better.
Because the object of the code is not to dissolve the company. The object of the code is to run the company as a going concern. So first chance is being given in the case of liquidation also, that if possible company can be sold as a going concern, company can have the proposal for mergers and amalgamation.
They do know that the entire going concern can be sold off. If it is not
Yes,
possible, then all the, as a block barrel, all the assets if can be sold off. If that is not possible, then part of the assets can be sold off. Otherwise, they go for liquidation last.
Yes, that is correct. So in that case also merger and amalgamations are possible. So first of all, the liquidator has to see the possibilities of mergers and amalgamation. So the company will be running company. It will not be dissolved.
That means in current days as a strategy for any distressed assets,
yeah,
this is the better route for merger and amalgamation than under Companies Act. IBC is more easier and more quicker.
In the starting that I have told you now that previous to the IBC, it was very difficult to sell the distressed assets because there were no route. So after IBC, the distressed assets of the companies are being taken over through the route of IBC or resolution plans.
How many total IBC cases has been done so far, which has been resolved through IBC since the implementation of IBC Act?
वो सर वो वेबसाइट पर अवेलेबल है, IBBI की वेबसाइट पर अवेलेबल है
पूरा ना?
Yes, complete data is available.
Sir, can a company be allowed to be amalgamated or merged if it is under SARFAESI Act?
If it is under SARFAESI Act?
Yes.
नहीं देखिए ऐसा है ना,
SARFAESI Act में भी होती है ना, तो कंपनी में क्या होता है कि जितने केसेस चल रहे हैं ना, that will continue.
Okay.
That will continue. अगर अमालगमेशन भी हो जाता है तो मर्ज भी हो जाती है, तो वो सारे केस ट्रांसफरी कंपनी सेटल करती है.
Okay.
कोई भी केस खत्म नहीं होता है.
Okay, madam. Thank you.
और इसी सेम प्रोविजन इज अंडर LODR also under regulation 37(7) कि the requirements as specified under this regulation and under regulation 94 of these regulations shall not apply to a restructuring proposal approved as part of a resolution plan by the tribunal under section 31 of IBC code, subject to the details being disclosed to the recognized stock exchange within 1 day of the resolution plan being approved. तो जैसा हमने देखा कि IBC कोड में दिया हुआ है कि अगर रेजोल्यूशन प्लान के का पार्ट है मर्जर और अमालगमेशन, तो उस केस में हमें सेपरेट अप्रूवल नहीं लेना पड़ता. उसी तरह अगर वो हमने विद इन अ डे वी हैव टू डिस्क्लोज टू द स्टॉक एक्सचेंज ओनली. नाउ थर्ड केस स्टडी इज अबाउट मर्जर ऑफ LLP into company. Can anyone tell me anything? LLP can be merged into company or not? So first I'll give the background. Companies Act 1956 this defines transfer company to include any body corporate. Transfer company means any body corporate. Body corporate की definition थोड़ी vast होती है, उसमें company or other body corporates can be incorporated. Section 230, 232 of the Companies Act uses the term company and not body corporate. Sorry, just a minute, sir. Section 230 and 232 of the Companies Act में कौन सा term use किया गया? Company. Body corporate word नहीं use किया गया है. LLP Act में क्या है? Provides for amalgamation of LLP into LLP. However, no specific provisions for amalgamation of LLP into company was there. तो LLP Act में ऐसा कुछ भी नहीं था कि LLP को LLP में ही merge करना है कि किसी और में merge करना है. अब इस केस में डाइवर्जेंट रूलिंग्स आई NCLT की. किसी ने परमिट किया, किसी ने परमिट नहीं किया. क्या है ये? NCLT चेन्नई बेंच इन द केस ऑफ रियल इमेज LLP एंड क्यूब सिनेमा टेक्नोलॉजीज प्राइवेट लिमिटेड. एक LLP है, एक कंपनी है. चेन्नई बेंच ने परमिट कर दिया मर्जर ऑफ LLP विद द कंपनी ऑन 11 जून 2018. इंटेंशन ऑफ पार्लियामेंट to permit merger of a foreign LLP with an Indian company under section 234 of the Companies Act. क्या लॉजिक दिया गया उन्होंने कि सेक्शन 234 में फॉरेन LLP को इंडियन कंपनी के साथ मर्ज होने के लिए परमिट किया गया है. तो इट वुड बी रॉन्ग टू प्रिज्यूम दैट एक्ट प्रोहिबिट्स मर्जर ऑफ इंडियन LLP विद इंडियन कंपनी. सेक्शन 234 में कहा गया है कि बॉडी कॉर्पोरेट मींस फॉरेन LLP कैन बी मर्ज्ड विद इंडियन कंपनी. सो इन्होंने प्रिज्यूम किया कि जब फॉरेन LLP अलाउड है तो इंडियन LLP भी इंडियन कंपनी के साथ मर्ज हो सकती है. So this is a case of omission of language in the statute. Casus omissus, that is case which was omitted to be included, but which would otherwise have been included given the same was covered in the erstwhile act. No express legal bar to allow merger of Indian LLP with Indian company. ये जो लॉजिक दिया गया इसमें परमिट करने का वो ये था कि फॉरेन LLP अलाउड है तो इंडियन LLP भी अलाउड है. एक्ट में ये छूट गया है. दिस इज ओमिटेड टू इंक्लूड द पर्टिकुलर प्रोविजन. सो इंडियन LLP इज अलाउड एज पर द चेन्नई डिसीजन. यस. फिर NCLT मुंबई ने भी अलाउ किया. वर्टिस माइक्रो सिस्टम LLP एंड फोरहेड सॉल्यूशंस प्राइवेट लिमिटेड में. No discussion on the issue of merger of LLP into company. फिर NCLT अहमदाबाद ने केडिया सेरेमिक्स पार्टनरशिप फर्म को ऑन 22/9/2017 में परमिट नहीं किया. लेजिस्लेचर इज इन द, तो उन्होंने क्या लॉजिक दिया? दैट इज दिस इज द लॉजिक. Legislature in its wisdom thought it fit to make available the provisions of amalgamation only to companies and not body corporate. क्योंकि section 230 and 232 में the word used is companies, not body corporate. No specific provision under the Income Tax Act for tax neutrality in case of merger of LLP into company. So tax implications for partners LLP and company need consideration. Alternative modes for achieving the desired objective of consolidation of LLP and company. Slum sale हो सकता है, conversion of LLP into company हो सकता है. तो इन्होंने NCLT अहमदाबाद ने अप्रूव नहीं किया. तो NCLT दिल्ली ने भी रियल इमेज LLP का जो केस था चेन्नई वाला NCLT में गया और NCLT ने उसको रिजेक्ट किया कि LLP cannot be merged into company. For merger of LLP into company, first LLP is to be converted into a company, then only it can be merged. And foreign company or body corporate incorporated outside India can be merged into Indian company. तो ये रूलिंग हमारी जो आई तो इससे ये क्लियर हो गया कि LLP को कंपनी के साथ मर्ज नहीं कर सकते. So this is now very clear that LLP cannot be merged with a company. तो हम लोगों ने एक प्रैक्टिकल केस देखा मोनेट इस्पात का, जिसमें रिजोल्यूशन प्लान में कई चीजें इंक्लूड करी हुई थी, और LLP का केस देखा कि LLP cannot be merged with the company. So from my side, I think it's over. If anybody wants to discuss anything, we can discuss.
Thank you very much, madam.
Thanks a lot. Sir, anything is to be discussed right now?
हाँ जी, नहीं बिल्कुल ठीक है मैडम. It was really wonderful session and I
Thank
hope.
Thank you, madam.
It was a wonderful session, ma'am. Thank
और
you very much.
इसमें ये है
Thank
कि
you. Thank you.
Thanks a lot, Gupta sir,
Very
for
helpful
bringing
session, ma'am. Thank you
हाँ
very
जी,
much.
such a talented person on the
हाँ जी, हाँ जी. और
platform. Such an
actually
experienced and
हाँ,
talented person.
हाँ. Actually मैडम
Thank you,
होता
sir.
क्या है कि ना हमारे यहाँ जो ग्रुप्स में कुछ लोग तो चल रहे होते हैं पुराने, जो
Yes.
2-3 महीने 6 महीने साल से भी पढ़ रहे हैं.
हाँ,
कुछ
हाँ.
लोग होते हैं नए जिन्होंने अभी पढ़ा ही नहीं कंपनी एक्ट, तो इसीलिए थोड़ा सा वो आता है. लेकिन ऐसा है कि हमारे यहाँ बहुत सारे कंपनी सेक्रेटरीज भी हैं और जो
हाँ.
पार्टिसिपेंट्स हैं उसमें बहुत सारे ऐसे भी हैं जो काफी टाइम से पढ़ाई कर रहे हैं.
Yes.
तो इसीलिए आई थिंक पार्टिसिपेशन वाज एनकरेजिंग, ऐसी बात नहीं. एंड मेंबर्स गिव आंसर्स आल्सो.
Yes, sir. Yes, sir. सर वो क्या होता है ना, कुछ अपन ट्राई करें, गलत होए तो भी ठीक है,
हाँ
उससे
जी, हाँ जी,
हमारे को सही चीजों का पता चलता है कि हाँ कि क्या व्हाट इज द लॉजिक बिहाइंड दिस.
बिल्कुल 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 बिल्कुल. हाँ जी, हाँ जी. और मैं जैसे आपसे रिक्वेस्ट किया है तो आप एक सेशन ना CIRP और इस मर्जर अमेलगमेशंस को मिला करके भी बना दीजिए, कि IBC को
ठीक है,
मिला
सर.
दीजिए उससे, है ना जी.
ठीक-
उसमें 2-3
ठीक है, सर.
सिनेरियो हम ले सकते हैं. एक तो ये कि रेजोल्यूशन प्लान में ही सजेस्ट किया गया है, और दूसरा रेजोल्यूशन प्लान डिसअप्रूव हो गया, लिक्विडेशन हो गया, और लिक्विडेशन में कॉम्प्रोमाइज की स्कीम
हाँ,
आई.
बैग लो बुक्स
इस,
पे
इस तरह से कुछ कर सकते हैं. वी
ठीक
कैन
है,
डू
सर.
समथिंग लाइक दैट. हाँ जी, हाँ जी. जब भी
सर
आपको
ये तो
टाइम
मैंने
मिले.
CIRP का लिया था, रेजोल्यूशन प्लान का लिया था. CIRP में रेजोल्यूशन प्लान में ही मर्जर पार्ट था, पार्ट
हाँ.
एंड पार्सल था,
हाँ
और
जी,
मर्जर और बाकी भी बहुत सारी चीजें थी, रिडक्शन ऑफ कैपिटल और ये लिया था. आपकी लिक्विडेशन का देख के बना दूंगी आपकी.
हाँ जी, हाँ जी, हाँ जी, हाँ जी, हाँ जी.
लिक्विडेशन में
तो
कैसे मर्जर का हुआ था.
हाँ बिल्कुल बिल्कुल. तो वी वंस अगेन थैंक CS and IP Manju Mundra ji for wonderful deliberation, and this session was being recorded for the benefit of all the participants, so you can watch it on our YouTube channel also in case you joined late or you could not attend the entire session. Thank you once again, and with your
So,
permission madam, we would like to end the session now. Thank you once
Thank you,
again.
sir. Thanks a lot, sir.
हाँ जी, हाँ जी.
Sir, if
Good night,
anything
Gupta
is
sir.
to be asked by any participant, they can ask in the WhatsApp group also, or they can discuss
Okay.
it in the WhatsApp group also, no problem.
Okay, madam has been added in the WhatsApp group, so you can ask questions in the group also. हाँ जी. Thank you madam.
Okay, ji, good
Thanks a
night.
lot, sir.
So we are
Thank
ending
you.
the meeting
Thank you,
now.
madam.
हाँ जी. Thank you.
Okay, sir.
Good night, ma'am. Good night, Gupta sir.
Okay, good night.